You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, a very warm welcome back to the Max Planck Lawcast. Today we're going to be talking about a crucial legal and political question, which is all about how a democracy can safeguard its core principles without inadvertently harming them. Now, to do this, we're going to actually be taking the example of Germany. I haven't decided on Germany willy-nilly, but rather because Germany has adopted an interesting approach to the aforementioned conundrum, namely it has adopted a militant democracy to actively defend the state against those who seek to undermine or abolish it. As we're going to be seeing, though, this approach is certainly not without its pitfalls, especially when it comes to balancing the right to free speech with the state's duty to safeguard its democratic foundations. Now, given all of this, I'm very thrilled to be joined today by two guests in the studio, Marc Bovermann and Johanna Fink. Both Johanna and Marc are doctoral researchers in the Department of Public Law at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg. Marc and Johanna, welcome to the Lawcast.
Thank you for having us.
Thank you.
Yeah, it's wonderful to have you on here today. So, lots to talk about. Let's get stuck into it. I wanted to begin by giving myself and our audience, a brief history lesson and to set the historical stage, if you will. Germany's approach then to defending its democracy kind of draws back to the Weimar Republic. So after the end of World War I, before World War II. Could you take us back to that era, perhaps, and explain why the concept of militant or defensive democracy was developed?
Yes, sure. I'm most happy to do that. Actually, it was really in that interwar period that the concept was developed, and both terms that you mentioned, so militant and defensive democracy, go back to the same concept, which was developed by Karl Löwenstein in 1937. So he started analyzing why fascism and National Socialism had emerged in Europe, and actually analyzed that anti-democratic forces would not have been able to emerge were it not for the pitfalls of the democratic system. And so he analyzed how the Nazis in Germany had gained power and saw that some mechanisms against anti-democratic forces didn't work well enough in the Weimar Republic. And he also saw that in some other countries, fascism hadn't come to power because some democratic mechanisms worked very well. And so he identified some very successful protective measures, for example, banning hate speech or defamation of democratic institutions through fascist propaganda, and also establishing, for example, a political police which monitored anti-democratic movements, or also the temporary suspension of fundamental rights in the face of movements that sought to undermine the state.
Okay. Can I just ask quickly, Karl Löwenstein, he was German? Well, the name is certainly Germanic.
Yes, he actually was German.
Okay.
He was Jewish as well, and he moved to the US.
Okay, so what he was writing about was occurring at the time in Germany, but he was then writing from elsewhere.
Yeah, and he didn't only write about Germany, but also I think he analyzed about, was it 15 states or something? 15 different democratic systems, or also anti-democratic systems in Germany. And he had a whole list, and he wrote two famous articles in 1937 where he had a whole list of, measures that were really protecting democracy and measures that weren't.
That's right. That's the kind of the conundrum, right? That's where we're going to be discussing then today about how this actually works in practice. I found as well the concept of militant democracy. I'd not heard of it previously. And when I first read your paper, I was like, what is this militant democracy? This sounds very unusual and strange. But now we're going to be talking through that then today. So I'm very, as I say, happy to do that. But we've got a lot to cover. So let's actually then jump then into my next question, which is, we saw what happened in Germany, the rise of fascism, the Second World War. Come 1945, obviously Germany is in ruins. We've seen by roughly 1949, West Germany is kind of getting back up on its feet, and it passes its constitution, or what's known in Germany as the Basic Law. Within then the Basic Law, the concept then of militant democracy is anchored. Is that correct? And why and how did they do this?
Well, you really mentioned the most important part of it already. So the founding fathers and mothers of the Basic Law saw what Nazism had done to Germany and, well, to democracy and to the whole of Europe, basically. And so the most important thing for them was that this should never happen again. And that's also why they, well, by the time, by 1949, a lot of people had heard about the concept Löwenstein had developed. There were also other people who had developed similar ideas, and then they sought to incorporate a set of safeguards into the Basic Law to basically make it more militant, so it couldn't happen again that anti-democratic forces destroyed democracy by democratic means.
Okay.
So the idea was really that anti-democratic forces couldn't turn democracy against itself.
Just from my understanding, that means that the Weimar Republic itself wasn't a militant democracy. Is
Yes.
that correct? Okay, so that this term came about during that period, but the Weimar Republic itself was not a militant democracy.
Weimar Republic had some measures also against anti-democratic forces. So, for example, movements could be banned as well, but that wasn't really enforceable. And that was also something Löwenstein had identified as being a real pitfall. He wanted also measures that could be enforceable. And this is what the founding fathers and mothers of the Basic Law took over. And we can find numerous examples of this actually in the Basic Law and also in statutory law.
And maybe it's also good to think about it not as a binary, right? As a yes or no in terms of is a democracy militant, but more as a scale. Like how militant is it? As Johanna already mentioned, we can find some examples for this within the Weimar Republic already. But now the Grundgesetz basically took it to a next level, took this idea very serious and implemented it as a basic principle, basically, of the Grundgesetz.
The Grundgesetz is in the Basic Law
Exactly.
of Germany. Okay, right. They said, we can't have a repeat of what's happened. They've looked at Karl Löwenstein's work and said, we like this type of a militant democracy, we'd like to, and then we actually put that into law. What then is, according to the Basic Law, the role of political parties in this whole process? That's certainly something that's talked about a lot at the moment, banning certain political parties because they run against the tenets of the Basic Law. So I'd like to ask, what are the responsibilities of political parties in accordance with the Basic Law?
Mm-hmm. The Basic Law states this very clearly. So in Article 21 of the Basic Law, we have in the first paragraph the function and the role of parties within our political system, which is to influence public will formation. I always like the idea of thinking about parties as sort of the intermediaries between lawmaking and society. So they pick up on these opinions in society and channel them into laws, politics, this other outlet. And even though some might think their role is fading and they're not as important normatively, our Basic Law and also the laws that are based on this, right, on this idea, they really depend on the functioning of those parties. So you can really think of Germany as a party democracy.
Not a party democracy, though.
No.
Sorry. I just thought about a party democracy. Sounds good. Okay. Right. They have a clear role then in the Basic Law. But if we're talking about banning a political party, does the Basic Law has a section, or is it in Article 21 that a party can be banned? If so, who actually decides whether a party is, I'm guessing, is it unconstitutional or that's what you would term a party then that's
Yes.
to be banned?
You would term it unconstitutional, at least that's what the translation says. Mm-hmm. And this is actually decided by the Federal Constitutional Court in Germany, which has the privilege to ban these parties. So this is what we call the party privilege in Germany, because there's no other entity which can actually decide on this. The parties themselves, they become constitutional already if they meet the thresholds and the preconditions, but it's only the Constitutional Court which can actually say that this is the case. And the hurdles are very high. So what we have observed is, of course, a value-based judgment, basically. We have to say these parties, they follow anti-democratic values. But now the Federal Constitutional Court has developed this further to also having a sort of hurdle in the sense of relevancy. So if a party is not relevant enough for the political discourse, as was the case with the NPD, so which is a right extremist party in Germany, which is now called different, this is actually why they weren't banned back in the day, because they just weren't relevant enough for German politics to take any influence. And this is expression of how important parties are to our democracy and how high the hurdles have to be in order not to overstep any
boundaries.
Yeah.
But I would say it also shows at the same time how ambiguous the role of political parties is under the Basic Law, because at the same time they have to form the political will of the people, and they also have to be democratic themselves. So in Article 21, both things are mentioned one after the other. I think this is really one of the first judgments the Federal Constitutional Court delivered. It was on a party ban procedure against the right-wing extremist socialist Reich Party, where they said that only if a party undermines the fundamental values, so really the core of what our democracy constitutes, it's only then that it can be banned. So you really have to look at, specific goals, and that has to be a long-term goal. So it can't only be if a politician says something once. So it really has to be a long-term
overarching long-term
yes.
view. Okay. And in this case, you were mentioning there, it was considered in the end that the party itself was so small and politically irrelevant on the grand scale of things. They said it wouldn't be proportional to ban this party because there is really no danger posed by this party to the Basic Law.
Which can, of course, be discussed, right? But
yeah, absolutely.
But that is at least what they held under the Constitution.
Okay, yeah. But the Constitutional Court doesn't go out itself and find parties that they think could be unconstitutional. These cases are brought then to the Constitutional Court by an aggrieved party, right?
Oh, not a party. No, that will really be a paradox.
Right, so it's not a party.
It's actually only 3 organisms that can file a motion to the Federal Constitutional Court. So that's the 2 chambers of Parliament, the Bundestag and the Bundesrat, and the government.
Any of these 3, though, could decide we feel party XYZ is behaving unconstitutionally, has been doing so for a long time, will continue to do so in the future. They can then petition or take this claim to the Federal Constitutional Court.
Yes.
Let's say, though, banning a party sounds obviously it's a drastic measure. Clearly it hasn't been used very often in Germany, probably because it is such a drastic measure. Did such bans, one, I guess, run the risk of damaging democracy? And are there 2 other, I guess, less draconian methods available?
That's definitely part of the paradox. The democracy uses anti-democratic measures, as Marc has said already, to hinder those forces that want to destruct democracy, to destruct it. But I would say there isn't a real risk that democracy is destructed by the militant democracy, because, first of all, the requirements for a ban of a party are very high. So because of that party privilege and the fact that only the Federal Constitutional Court can decide of it, that's already quite a big hurdle. And then also because the Federal Constitutional Court has got such high standards itself. And I think what also shows that is that only 6 procedures to ban a party were started before the Federal Constitutional Court so far, and only 2 were successful, actually.
Oh, okay, but there were actual parties banned?
Yes,
okay.
But that was in the very beginnings as well of the Federal Republic.
I wonder if then they just reconstitute, though, as another party, right?
One of them actually tried, so that was the KPD, the Communist Party, but then I think it was dissolved shortly afterwards.
Okay, so it is kind of a death knell. If your party is banned, then that's fairly clear that you're politically in trouble.
Yes.
Yeah. Okay.
It also highlights that a party ban is really a last resort. And I think you can think about it as a sort of like maybe emergency button, which the Constitutional Court can press to really sound the alarm on a party, to prevent this party from doing even more damage. But of course, it's always a bad situation if you sound an alarm, right? So you have to be really careful about it and think about the consequences.
Okay, and you say sounding an alarm as in firing a warning shot over the bow, or when the button is pressed, then this party's banned?
In a sense, this party is banned, but in a sense, it's a warning shot for our democracy. It's trying to protect our democracy as a whole, the functioning, so that it cannot be undermined, for example, by fascists again, which would then get rid of democracy in the end. In that sense, it's a warning shot.
But at the same time, that's also, you ask if there's less draconian options available.
Yes.
I think really the options under statutory law are most important. And in that regard, the most important role is played by the Federal Office for the Protection of the Constitution.
Yes.
And also by the 16 state offices for the protection of the Constitution, because they have to observe anti-constitutional activities, collect information about them, but also inform the public about it. And so they publish reports, so-called reports on the protection of the Constitution, Verfassungsschutzberichte, in which they evaluate different, things politicians from specific parties, but also organizations close to those political parties might have said. And they try to, inform the public through that and thus make people aware when they go to the polls and just not choose, for example, a party that has been mentioned in the report.
Okay, but they're also, at the same time, these reports then also send as a warning to the parties to be careful about the line that they're treading there.
That's the idea of it.
Okay.
I wouldn't say this always functions very well because, to take the example of the AfD, which has been declared certainly right extremist a few weeks ago, it has been observed for quite a long time already and also mentioned in the report. But, nothing really has changed so far. Neither has the party or the politicians in the party haven't started moderating what they say, nor have voters turned away from the party.
Following the politics of, there seems to be a lot of discussion and dissent between the various political parties or the government as well, what to even do with this information.
Yes.
Some parties are saying, we should take this to the Constitutional Court. Others are saying, no, that's the wrong way to deal with this.
Yeah.
I think maybe it's important to also see these measures not as sort of a preparation for a party ban, right? These measures, they have their own justification. They're important to inform the public and sort of steer discourse in a way, right? You can, of course, also see that very critical from a freedom of speech sort of perspective. But this is the way that it was constructed in Germany. And I think it's also too early to just say something about whether this intervention in the end into the marketplace of ideas, right, has failed.
Well, I'd say we're going to go for a very short break. And to my listeners, or to our listeners, I'll be back with Marc and Johanna shortly just to discuss more about democracy, protection of democracy, especially in the digital age.
Max Planck Law is a network of Max Planck Institutes engaging in legal research. The first of these was established in Berlin in 1924. Today, we cover a broad range of legal studies, from the anthropology of law to tax law. We operate one of the world's largest programs for doctoral and postdoctoral research in law. Visit our website today at law.mpg.de.
Well, welcome back to the Max Planck Lawcast. I'm joined today by Johanna Fink and Marc Bovermann, and we're discussing Germany's militant democracy and how it seeks to balance free speech with the protection and maintenance of the democratic order. Okay, so Marc and Johanna, we discussed a lot of political and constitutional theory there before the break. Let's get practical, shall we? We're talking about bringing a case to the Constitutional Court, but we also talked about less draconian measures, and one of this was to the Bundesverfassungsschutz, is that correct? Okay, and this is like a constitutional intelligence gathering or anti-constitutional behavior intelligence gathering agency. Okay, so they're responsible for checking if a party or members of the party or groups associated with the party are behaving in an unconstitutional manner.
Well, they don't only check on parties. It's, basically Germany's domestic intelligence gathering service. But looking at parties or also generally anti-democratic behavior is their core.
Their aim, though, is the Constitution. That's what they're protecting. Or they're, when you say it's like the Internal Intelligence Agency, is it like
it's not quite broad.
It's not the FBI, though, or is it?
I guess that's sort of the problem with how you can perceive this office. Because in some states in Germany, this very office, like the Internal Intelligence Services, they also investigate into organized crime, for example. This can be seen very problematic But I guess like historically, the core is what Johanna mentioned.
Okay, because that's right. They're not really a police force then in this.
Oh no,
No,
yeah,
okay,
they're
okay.
even really not allowed to do any police measures. So that's also one of the something the Allies actually obliged the founding fathers and mothers of the Basic Law to put into the Basic Law, or at least, well, it's quite debated. It's a so-called principle of separation, the Trennungsgebot, which obliges police and intelligence services not to work together.
So it's an intelligence agency, though, looking at unconstitutional behaviour and sometimes organised crime. But its main charge is to look for unconstitutional behaviour in German society, internally within Germany, its borders. Okay. Now, this is obviously, I'm sure most or all countries would have some kind of intelligence gathering agencies, but Germany has history, and also during the East German period there was also a lot of this concern as well with the government spying on individuals. How has this, the history of Germany, shaped what these confidential informants can and cannot do?
How the history has shaped this is, I guess, that's something maybe we can discuss after. But I first want to make maybe the distinction, because we're talking about covert informants now. I think it's important to say that there are 4 types, but mainly 2 types of these informants, which are covert agents, which are actually employees of these offices. And then there are also covert members of the group, maybe, who are recruited by these offices, who are already members of the movement which they want to surveil, and are then basically recruited to the good side, if you want to call it that.
Right, okay. So they're a classic informant then, basically.
A classic informant in that case. And I guess it's important to separate both of them. Both have their own problems. They're very similar. And of course, the state makes use of both of them. So they're obliged by fundamental laws to abide by them whenever they use both of them. But the latter group, so these classical informants, right, they have some special problems of their own. Maybe you can think of them as sort of covert witnesses who also proactively investigate within these movements. This is the role they play. So they give information to the office and they gather information themselves.
By the office itself has gone out and found these confidential informants, or they've placed them there as well? I guess both options.
Both is possible.
Both is possible, okay, yeah.
Both is possible. I'm not actually sure what happens more in practice. I guess it's like also sort of a secret.
I think, yes. Yeah. That's what we do.
Maybe an educated guess would be that it's probably easier to get to people who are already part of these groups through incentives like money, or not have put them in prison, stuff like that, I guess. Yeah. Okay. But this is like really important, because these informants, they played an important role during the already mentioned investigation into the NPD. So this right extremist party, which was not banned after all, but close to being banned. They had lots and lots of informants within this party. So much, in fact, that they couldn't even tell which information was now spread by people working for the government and which was actually contributable to the party. Okay. So basically, the information in the end was sort of worthless.
Okay.
And another factor
because the party had been overrun by informants.
Exactly.
Yeah.
No one knew who was an informant and who wasn't. Okay.
Yeah, I think that's really part of the danger always. So those covered agents really must make sure that they don't influence the party's decision making, because the Federal Constitutional Court ruled in that decision that if confidential informants take a decisive influence on the political will of the party, then you can't say that that's real evidence that the party is anti-constitutional. Okay. Because part of the party privilege in Article 21 is also that parties are free of state influence. And so parties must, from that, parties will think that everything they discuss internally is kind of free from state influence. And so there's some kind of trust there as well. So if state informants infiltrate and really take some, say, for example, well, let's do publish this next or something, and then you can't really attribute
force the hand of the party to behave unconstitutionally. Yeah. Then yes, I understand that would be a problem.
And another factor which is also important in this context is, of course, you're paying members of the group money to work for you. So you're actively financing these sort of unconstitutional groups, right? And that, of course, in itself, a bit paradoxical, because you're paying for people who are doing what you're actually trying to prevent.
Yeah, that's right. And I mean, maybe they've also got an interest as well in continuing what's going on there. I mean, if they're on a good wicket, they're being paid, and then they'll be like, well, we'll continue. I mean, we can't insinuate, but it does sound a bit murky, the whole situation.
It does.
Yeah, okay. Yeah. I'd like to then ask about, I mean, so we've got this situation with the constitutional informants, but obviously not everything now happens in party rooms and behind closed doors. We've got the internet, and there's all kinds of discussions and chat groups and going on there, and it's really altered the way that, I guess, political extremism occurs in Germany and abroad as well, everywhere. I mean, what strategies are then now employed to deal with this new threat?
I wouldn't say that internet has really altered extremism per se, but of course digital communication brings a whole new evolution to public discourse with it. So, for example, because of algorithms, some political ideas or, well, threats will be pushed further. And we also saw this in some elections that were held both in different states and, well, also the federal elections in Germany since last autumn and beginning of this year. The AfD always became the second strongest or the strongest force after the polls, and it particularly had a significant increase in the 18 to 24 age group, and that also correlated with the party's social media dominance in that age group. So yeah, we really see that some parties know much better how to influence the discourse going on social media much better than others. That's definitely something that the classic officers for the protection of the Constitution haven't realized enough how to handle this. Although I would say in some federal states actually there have been measures in that regard. So the competences of the officers have been widened in some states. For example, the officers may access social media accounts through the login masks. If they've got, well, the login codes like the password and things, they can also be deployed on those platforms as long as they do not exploit the legitimate expectations, so that trust that I was talking about of the party.
We now have constitutional informants also working online, basically, in chat rooms, on private, public, and also posting, reading posts, discussing.
Yeah, we do.
Okay.
And I think it's also important to keep in mind that most of it's always been the case, right? Because one of the most important intelligence sources for the offices is just open source intelligence, right? And with all of this being public information, you basically know that the offices have always been reading what we've been posting online, right? And I think it's super important to keep this correlation in mind between, right, the people voting for the AfD more and it correlating with the social media use, is that at the same time the role of the platforms is still unclear. So maybe if I can bring in a small example,
yeah, please do so.
Which could be interesting, is that something that's always been discussed in this context was the alt-right pipeline, which was promoted by YouTube. Maybe not. I guess this is sort of the question at hand, whether YouTube has actually encouraged a sort of alt-right pipeline, which would go like this. You would click on a video, which would be sort of anti-woke, anti-social justice sort of video, and these people would hook you in, and YouTube algorithmically would then recommend you through the recommender systems similar videos, and these people would abuse these recommendations to recommend worse and worse content. So you would go down a pipeline, a rabbit hole of right extremism, where they ultimately would lure you away from YouTube to more hardcore extremist content. This is something that's been discussed for a long time, whether that's actually the case, different studies on that. You can't find very definitive proof of that actually taking place. But I think it's a legitimate risk, a legitimate concern to have.
I'd like to now address the elephant in the room, which I guess is the very nature of a militant democracy. Does it not create the inherent danger of overreach? I mean, we talked a lot about this kind of murky things happening in the background here. Things are not necessarily happening out in public, although the eventual decisions do clearly have an impact on the general public, whether a party is to be banned or not. And is there not this problem that we might be even silencing political dissent?
Yeah, well, technically, you always have that risk, I think, as soon as you start interfering in free speech and party will formation. Also because the Federal Office for the Protection of the Constitution is in fact reporting to the Federal Ministry of the Interior. So we've got some kind of political dependency there. Although at the same time they really act autonomously. So they make their findings autonomously without political interference, and they really make sure to state that as well. Also because this is something that the AfD is saying now, so that the officers for the protection of the Constitution are in fact the puppets of the government, and that the government is waging a political vendetta against them, especially the current government, because they couldn't defend the AfD at the polls. I think also it always creates a stigma if you mention a party, for example, in those reports on the protection of the Constitution, and you obviously can pose the question if that interferes with a party's rights to equality and to fairness in competition, the marketplace of ideas. But that's also at the same time why we have such strong measures and such restrictions and limitations on what can be done. At the same time, we talked about history in the first episode, and history definitely has taught us that some measures have to be taken and might have to be anti-democratic to prevent anti-democratic forces from turning democracy against itself.
I totally agree. Johanna really mentioned these two sides of the coin, right? We have the intervention into a free marketplace, and on the other hand, we cannot just sit and watch while bad actors undermine democracy, right? So we have to strike a balance somewhere. And there are examples for both sides where the state has, for example, intervened wrong. It's been discussed as the lying about the Holocaust. That's forbidden by criminal law in Germany. And that might be actually unnecessary. Not because lying about the Holocaust is a good thing. Of course not. It's stupid. But it's also maybe not necessary to ban it by criminal law. Because if everyone agrees that the Holocaust happens and the people who are claiming that the Holocaust is a lie are nutcases, this is not a problem and there's no state intervention needed. So I guess it's like really about the right balance, finding the right balance to protect these public interests, while also on the other hand, not overreaching into the marketplace of ideas and letting those market forces be at play.
Let's now briefly do a segue to the European level. Marc, I know you've done a lot of work. Is it on the DSA? Is it the Digital Services Act?
Exactly. Okay,
and this is well, maybe you can actually tell us what it is and how it has a role in defending democracy.
Yeah, so this is a very interesting question. So first of all, the Digital Services Act, it's a rather new regulation by the European Union. It has actually been drafted and released back in 2021, 2022, but it's only now been in force since a little bit over a year now. And it's supposed to be, and some have claimed that it's basically the constitution of the internet. Okay. It's a very bold claim, very big claim. And I'm not sure the DSA can deliver on that claim.
Okay, yeah, it's hidden in an interesting package as well, the Digital Services Act. You don't quite know what's inside.
Yeah, what's inside, right? It's about digital services. It's a package because it really is a package deal, because it's not only the Digital Services Act, but also the Digital Markets Act, which plays a big role in regulating these online platforms. But this is what it's at heart of the Digital Services Act. And it's now up to debate, or we can see how actually this act might serve to protect democracy, which is a bit hard, because even though militant democracy can also be understood as a European tradition, it is not explicitly mentioned in the European Constitution or within the DSA. So you sort of have to do some interpretatory work to read that into the DSA. But if you do that, you have some tools which could be really helpful in actually protecting democracy. So the first one we looked at was, for example, the Trusted Flaggers program, which has been discussed in the public eye for a little bit some time ago. It's basically in addition to a notice and action mechanism. So this notice and action mechanism, what it describes is that you can report content which you disagree with or find to be illegal to the online platforms, which then have to decide whether this content stays up or stays down.
Posts on Facebook or on X or on a newspaper, I guess, or in one of those forums there, I can then flag it and say illegal or offensive, and then they have to look at the flags and make a choice.
Yes, the thing with the newspapers and forums, that's quite something else. Okay. So online platforms, this is like a very strict definition, and then all these online platforms also have to have 45 million users. So these forums would not fall under the definition of an online platforms in the first place.
Okay, they're really going after the much larger online platforms and forums.
Exactly.
Okay.
So this notice and action mechanism, it applies to all online platforms. It doesn't have to have 45 million users. There's additional obligations for bigger platforms. But notice and action is for every online platform. But as these forums for newspapers, they're not the main event, basically. So this is why they're not considered to be online platforms. If people were to use these newspapers sort of as for the forum as the main event, it might be different, but that's not the case. So you wouldn't be able to report this content under the DSA, but it's more Facebook, Twitter, Mastodon, Reddit, even like
And
the
that already
ones.
exists then now. There's the option now to inform if a content I believe is illegal is there, then I can inform by pressing a button or...
Exactly. It's supposed to be very easy. It's not easy. In most cases, but you can just inform the platform. And then they have to decide whether this content stays up or goes down. And now these trusted flaggers come into play. They do the same thing. They go through the platform and report content which they find to be illegal to the platform. And now, because these trusted flaggers have been chosen in advance...
By the platform,
by a state agency.
A state agency.
The Digital Services Coordinator in Germany or every other member state. They have to have some structural obligations which they have to oblige by. These reports by these trusted flaggers, they are prioritized by the platform. So they are basically more important because the quality is assured of these reports. And they have to be worked on faster. The offices in Germany protecting the constitution, they could serve as such trusted flaggers.
Okay. And they may well be doing so.
They will not yet.
Not yet, okay.
There are very little amount of trusted flaggers yet in the EU in general, but it's possible. It's something they should think about, to actually register as a trusted flagger and then report to online platforms content which they find to be illegal and which also undermines democracy. This is a way for them to also prevent anti-democratic movements.
This is a new attempt by the EU then to say we've got new challenges online. How can we approach this?
Exactly.
Okay. The DSA, or someone who's not a fan of the DSA, is J.D. Vance. Now, he's the Vice President of the United States of America, and I believe it was beginning of 2025. He was here in Europe, and he really ripped into the Europeans and the member states for their lack of free speech, their attacking free speech. On top of this, we had several current affairs shows at the beginning as well of 2025. Seemed to be a busy time there, and obviously the changing of the administration in the US, but they were reporting, and I mean, there's 60 Minutes, they're well-known outlets, they're reporting about heavy-handed policing of the internet in Germany. How do you think Germany's approach then to defending democracy differs from the US, and what is the international perception then of Germany's stance?
I think this is a very interesting question because it's very discursive right now, right? Really dividing topic. And I think from an individual perspective, what I found always very interesting, I don't think the First Amendment and Article 5 of our basic law are that far apart. The big difference is, of course, that under the First Amendment, every utterance of speech is at first protected, right? Like a priori protected, which is not the case in Germany. For example, facts, the utterance of fact is not protected under the basic law. It's just about opinions. And if you look at the outcome, though, these interferences can be justified, for example, due to some individual being defamed and then this individual perspective on things. I think the outcomes are often very similar. But where there's, of course, a big difference is in terms of how they also look at public opinion, how public opinion is protected in both countries.
That's maybe also something that J.D. Vance lets out a bit, because I think why we've got this difference, that's really due to the historical past of both countries. So the US Constitution was founded in an era where liberal ideas were very much on the forefront. You didn't want the state to intervene too much. The settlers in the US also wanted to loosen themselves from the British state, which they found interfered too much with their ideas. And, the German basic law, we've discussed about that already, wanted to prevent authoritarianism to happen again in Germany. And so it was important that certain ideas really couldn't spread or couldn't gain too much power.
I think it's also about culture. For me, the big difference is the protection of the public opinion. So in the US, it's like very individual-based perspective, and the public opinion is, of course, affected, but you don't have, not as I'm aware, of justifications.
That's really quite important, I think, that in Germany, the protection of the free democratic order, so basically of, our society, is playing a big part. And in the US, it's very much about what the individual wants and what the individual thinks. So we've got society versus individual there as a perspective.
Right, understood. Okay. Then let's leave JD Vance and his comments on the DSA behind, because I want to wrap up the interview today. We've talked for a long time, which has been great. I've learned a lot. And I wanted to now ask whether you feel optimistic about the way things are heading here. Politics is increasingly divisive, increasingly toxic. Clearly, the Basic Law has done a good job at stopping Germany falling back into eras of the past. So, it's done a great job for the last, 60, 70, 80 years. Where's it heading in the future? How do we feel about whether it's ready to defend German democracy in the future?
Well, that's, of course, difficult to predict. But I would say that the Basic Law is definitely still able to protect German society, or also the free democratic order, although we've got very strong tendencies of political extremism at the moment. But, there have been some tendencies like that in the past already as well, even though, of course, in the past we didn't have disinformation and online hate speech. But there were similar issues. Don't forget, Löwenstein, actually, he already stated just after the war that the political climate had changed quite a lot, and he was very afraid about what he called means of mass communications, and he meant television and the radio by that, because he was concerned that the public would be exposed to too much extremist talk, and also, especially through the radio, that information wasn't filtered enough, as it was, for example, the case in newspapers. He thought that, individual thoughts could be influenced a lot quicker. And we've basically got the same discussion nowadays with platforms such as TikTok. It's really the same discussion. So I wouldn't say there's some kind of an internet exceptionalism or something there. It's not really a new phenomenon, although definitely things go a lot faster nowadays. Then the Basic Law's strength also lies in institutions. So we've talked a lot about the Federal Constitutional Court as well. And I would say that's really a stronghold, and also something that people from all political backgrounds have a trust in. So even the AfD, when they are not d'accord with something the government says, they just go to the Federal Constitutional Court. So that's definitely a big stronghold.
What you mentioned is very important. And I think my main takeaway would also be to put more focus on the invisible hand of the marketplace of ideas, right? To value conflict, to see not conflict as something that's destroying us, but it's something that's helping us progress further, right? So there are big divisions, which is maybe, to start with, not that bad. Of course, people are different, and we're in a constant conflict back and forth and trying to optimize society. Most of us have the same goals. And when we don't have the same goals, I don't think the conflict is maybe legitimate again. And it is there where we should tread carefully. When this conflict leaves the premise of being open to all or being democratic, these forces cannot work anymore, and we should prevent that from happening.
Okay. Well, thank you, Marc. Thank you, Johanna, for taking the time to be with me today, for talking that through. I found it very, very interesting. I've learned a lot. So wish you all the very best with the rest of your studies.
Thanks for having us.
Thank you.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.